Now let's spend a few minutes to talk about the role of administrative law judges. Now the interesting thing is that under the law, the final decisions in any adjudication are not made by administrative law judges, but rather by the agency head. The administrative law judge conducts the hearing, but their decision simply acts as a recommendation that has to be reviewed and ratified by the head of the agency. In addition, the head of the agency has the legal right to preside over the actual formal adjudication hearing themselves. So if, say for example, the Secretary of Commerce or the head of the Federal Trade Commission is interested in a particular case, a particular adjudication, they could move the administrative law judge aside and take their seat and actually preside over the hearing. Now, this is something that happens very, very rarely, but this demonstrates the role that the administrative law judge plays in terms of only being a recommender, not a decider. But the vast majority of cases are heard by them, and so they still have a good deal of influence. And of course, they are employees of the agency, so in some respects this creates a bit of a conflict of interest, because usually it's the agency that's bringing the adjudication, but nevertheless, despite this conflict of interest, they still hear these various cases. Now there are about 1,500 of these administrative law judges, and they're housed within particular agencies. They're spread out across the federal government. And just to give you a sense of the number of administrative law judges in various agencies as of July 2019, by far the largest number of administrative law judges is in the Social Security Administration. So these are dealing with cases of individuals who have been denied Social Security eligibility, and they are contesting that. And you can tell they are by far the largest agency with the largest number of administrative law judges, because the second largest number of administrative law judges in any agency is in the Department of Health and Human Services, and those are judges that are dedicated to deciding Medicare disputes. So both of these groups of ALJs deal with individuals who've been denied eligibility for various social welfare programs. But you can tell Social Security Administration has more than 16 times the number of administrative law judges than the next largest agency. And then it just goes down from there. I'm not listing every single agency that has an ALJ, but for example, the Labor Department has 41, the NLRB has 34, and then you get down to, for example, the Securities and Exchange Commission having 5, and then you've got some agencies that only have 1 administrative law judge, such as the Federal Trade Commission and the Federal Communications Commission. ALJs are different in many ways from federal judges, of course, because federal judges enjoy lifetime tenure, and they also enjoy salary protection, meaning their salaries can never be lowered. They also have to be appointed by the President and approved by the Senate. That's not true of ALJs. They don't get lifetime protection, they don't get salary protection, and they don't have to be elected or selected by the President, although that certainly is an option. So one interesting thing has happened recently. Recently there has been a dramatic change in the way that ALJs are appointed, and this may have an influence on their independence. As we've mentioned, ALJs are supposed to try to be independent. They're supposed to be like regular judges, to be influenced simply by the law and the evidence, and they shouldn't be influenced by political factors. And we talked about the various ways that the APA tries to guarantee their independence. Well, they were also guaranteed their independence, or hopefully, by the way that they were appointed. Their salaries were set by the Civil Service Commission, not the agency, so the agency couldn't raise or lower somebody's salary based on their decisions. Their names for hiring had to come from the Office of Personnel Management, so there's a federal agency that screens potential candidates for civil service jobs. All names had to come through there, so ALJs, like all civil servants, had to be subject to a competitive exam. And in addition, they could only be fired for cause after the agency had proved their case to the Merit Systems Protection Board. So there's a board out there that would review any instance of a civil servant being fired, and they could only be fired for cause, at least the administrative law judges. And of course, the cases were also assigned in rotation, so they were assigned randomly, so nobody assigned the cases intentionally so they couldn't be manipulated. Well, the thing is, very recently, much of this was called into question by the Supreme Court's decision in Lucia v. SEC, which was decided just in 2018. In this case, the court decided that the method of appointing administrative law judges that I just described was unconstitutional, and they decided it by a 6-3 vote. So again, that's just a couple of years ago, a huge change. And the reason that they did this should be familiar to you because of things that we talked about earlier in the semester. The court decided that administrative law judges are indeed officers of the United States, so they fall under the Appointments Clause that we've discussed. They are not superior officers, they're inferior officers, but that means they must be appointed by the president, by the head of their department, or by the courts of law. And that was not the way these judges were appointed. They were not appointed by any of these three groups. And as a result, the Supreme Court said that this was unconstitutional. Now again, this was just very recent, and so things are still in flux. But what has happened since the Lucia decision? Well, there are certain questions that are unclear, and it will probably result in later Supreme Court decisions to clarify these questions. For example, Lucia did not involve the firing provision, it only involved the hiring provisions for judges, but it does raise the question of whether the good cause firing provisions are unconstitutional. Another question that's been unclear is whether it only applies to the SEC. The Supreme Court said that it did, but it's entirely possible it may apply to all administrative law judges, and in fact, the Trump administration and the agencies have assumed that it does not apply only to the SEC and that it's going to apply across the board. Now, in the short term, what's been happening is department heads have been ratifying previous ALJ appointments. So all of these administrative law judges that were appointed in a way that we now know is unconstitutional, the department heads have been going back and retroactively ratifying those appointments because, of course, department heads are permitted to make those appointments under the Constitution. Now, following the Lucia decision, President Trump issued EO 13843, which removed the competitive exam requirement. So previously, as I mentioned, ALJ judges had to take the civil service exam. That requirement is gone. And so the question is, does that mean that we're not concerned with merit anymore? Well, under EO 13843, each agency gets to decide for itself the process and criteria for hiring, but they assure us that it will nevertheless retain merit-based multi-member decisional components, meaning they're not intending to throw merit out the window, but they're simply not going to measure it by a merit-based exam. Well, this is a little concerning to the independence of administrative law judges, and it's also concerning when considering the changes that were made to immigration law judges in April of 2017. In April of 2017, for the first time, the Department of Justice required immigration judges to meet quotas. And what these quotas were, there were several of them. I've got the two most important ones listed here. But under this quota system, they had to process at least 700 cases every year. And then those cases, of course, are reviewed, and less than 15% of those cases should be returned. And any judge who did not meet these metrics would be given a low rating each year. Now, this was a plan that was condemned by the National Association of Immigration Judges. They said, and they're absolutely right, that this, although it seems neutral and it was couched in the phrasing of having more efficient judges, the fact of the matter is immigration cases can be extremely complex. And some immigration judges hear substantially fewer than 700 cases a year. And so setting a 700 case a year quota, the thinking is, will encourage those judges to simply deny more of the immigration cases as a way to clear their docket. And so we haven't seen any immigration law judges be disciplined as a result. Again, this is a very recent change. But if you take these two things together, the Lucia decision and this recent change to the immigration law judges, it's clear that the role and the independence of administrative law judges is currently under attack.